Welcome to Justice Matters. I'm Denise George, Attorney General of the U.S. Virgin Islands. Justice Matters is a program aimed to inform, engage, and empower you with knowledge about Virgin Islands laws that affect our everyday lives and our community, with insightful discussions with special guests on our laws, our justice system, and related topics so you can be empowered to make a difference in our community. Today, we are talking about the anatomy of a criminal case. What really happens from crime to arrest to prosecution of a criminal case, the criminal process and the roles of the police, prosecutors, and the courts. Under Virgin Islands law, the Superior Court of the Virgin Islands has original jurisdiction over all local crimes, and the Attorney General prosecutes crimes before the courts, usually after an arrest by the Virgin Islands Police Department. But a lot happens between the arrests and the final court decision. I always say the roles between the Virgin Islands Police Department and the Department of Justice, Attorney General's office, is like a marriage where divorce is not an option. We work hand in hand. And joining us now is Amie Simpson, attorney. Amie Simpson, she is the criminal chief of the St. Croix District of the Attorney General's office. And she's here to discuss this process of crime to conviction or acquittal. Attorney Simpson, welcome to Justice Matters.
Thank you, AG.
How long have you been a prosecutor?
Oh, I have been a prosecutor since 2013, however many years that is.
Okay, for quite some time then. So where do we start? Where does it start?
Well, I think obviously we'll start at arrest, and that's where I think that people become aware of the big cases or the cases that involve themselves or their relatives. But I think they're very unclear on what happens after that arrest.
Okay, so we have a crime happens. The police department, the VI police, they're the first responders. There's an investigation or something, maybe a call, and then an arrest is made. Probable cause is found, right? Or there's an arrest. Okay. So what happens at that arrest, right after that arrest?
Well, at the arrest, obviously the person being arrested needs to be told what they're being arrested for and be read their rights, and then they'll be taken into custody. And I think this is where it gets confusing for people because unless it's a crime of domestic violence, people can bond out immediately after arrest if they have enough money to make whatever bail is set.
That's right. And then as far as domestic violence arrest, tell me what happens then.
So for domestic violence arrest, here and almost everywhere in the country, if you are arrested for domestic violence, you cannot be released until you have seen a judge to set bond. Now, sometimes we see folks come in for advice of rights and be released that way, but you can be released by seeing a judge earlier if you're able to arrange to do that.
First of all, how likely is it that you will get to the court within a day? Or do you have, remember, there's with respect to there's a time frame constitutionally, right, within which a person who gets arrested will be able to see a judge. What happens then?
You must be brought to court within 72 hours to be advised of your rights. And so that is why right now in St. Croix, at least, we're doing advice of rights on Monday, Wednesdays, and Fridays. But there may be situations where we have to advise somebody specially because there's a holiday or whatever, and we need to make that time frame.
What happens at advice of rights when a person is arrested for a crime?
The first thing that happens is that the person is brought before the judge, and the judge wants to make sure that there's a basic understanding of that they understand the process. And so he'll ask them to state their name, and then the judge, he or she, will explain the charges and what the penalties are, and will then advise the person of their rights.
Okay. When they do that, though, is there a consideration as far as release and whether or not they will be released to the public, or whether or not they go and they have to stay in jail?
As soon as all of the first part is over, then we do talk about release. And sometimes the defense and the prosecutor have conferred a little bit beforehand so that we can at least see what everybody wants to have happen. And the judge will then set bail. And the judge sets it according to a variety of things that they look at.
And what are those factors?
So that would be the danger to society, whether this person is a flight risk, whether there is a particular victim who may be in danger if this person is released, all those sorts of things.
And what is, as a prosecutor, as an assistant attorney general, and there, what is it that the types of arguments that you make to the court with respect to those factors in determining whether or not a person arrested for a particular offense ought to be released or released immediately on their own recognizance, or that bail should be set.
Well, those arguments are somewhat difficult because we cannot just base our argument on the particular crime that's been committed, because, of course, this person is innocent until proven guilty. So we have to be able to demonstrate to the judge all of the reasons why this person might be a danger. So not only the type of crime the person's been charged with, but what their criminal history is, things that they have done maybe at the scene of arrest, other things that show that they are dangerous. As far as flight risk goes, we look at the type of crime that's been charged. If someone's facing a long time in prison, they may decide to flee. So that may make them more of a flight risk. We do also look at their criminal histories. And if we see that they've been a flight risk in the past, that they've failed to show up for court, that's another argument that can be made.
Mm-hmm. But flight risk, to what extent do they look at the ties to the community as well in determining that?
They see how long someone's been living here, whether they have employment, whether they have family, whether they have a home that they want to stay in, whether they have children. And yet, even those things sometimes will not stop a person from trying to leave the territory if the crime is serious enough.
And when you're considering your arguments regarding whether or not the person is a danger to the community, how and to what extent are you looking at the protection and the safety of victims or members of the community if this person is released?
The safety of our community is a prosecutor's first priority, always. The safety of particular victims as well. And then we have to look at whether the type of crime that's been committed is something that may be repeated once the person gets outside, either by them or by some opposing faction. Mm-hmm. We don't want to put anybody in harm's way. We don't want to have any more gunfire on the streets.
Mm-hmm. And so once these arguments are made, you make one argument, sometimes you have an opposing defense, the defense makes an argument. How does that process go? And then what are the results? How are they done?
The defense will obviously make their argument that their client should be free with the least possible restrictions. Mm-hmm. Luckily, we do have electronic monitors here in the territory, so that is often a good compromise with a crime that's fairly serious, but we still want to be able to keep an eye on that person and make sure that we know where they are at all times. So that is a possibility here. The judge will eventually make a decision and set the bail. Mm-hmm. Often the judge will set a third-party custodian, and then they will dictate the terms of the person's release.
What happens if a person is released or they're released on the electronic monitoring and they commit an offense while they're on release? What happens then?
We would then do a motion to revoke their release. And if they commit a new offense and are arrested for that, obviously that's going to be taken into consideration when their bail on that offense is determined.
Mm-hmm. So who is it that makes the motion then?
We would, as the prosecutors.
The prosecutors would make that motion. So there's the arrest, the advisement, and what happens next?
Well, the person either then would be released or they would return to jail and await their arraignment. Mm-hmm. So when the person is arrested, we file a probable cause fact sheet that says what happened, but we haven't yet filed the formal charges. So at the arraignment, then we have the charging document, which would be either a complaint or an information that sets out in writing and according to statute what the charges against the person are. Mm-hmm. The purpose of the arraignment is what people see on TV, is that the defense attorney says that they understand the charging document, that they don't need it to be read. They plead not guilty to all of the counts in the document. And then at that point, the case is assigned to a particular judge and scheduling begins.
What is the information and what describe the types of, or things that you can expect to see in an information?
Sure. So first of all, there are two types of charging documents. One would be a complaint for misdemeanors. So we might see that in a DUI, for example. Mm-hmm. And that document would set out all of the statutes which we are claiming that the person has violated, and the actions which they took in order to violate those statutes. And that's important because a person has a constitutional right to know exactly the acts for which he's being charged. So we have to be specific and clear. In the Virgin Islands, we do not have a grand jury. So instead, we charge felonies by informations, and the felonies then would be anything that's punishable by more than a year of imprisonment. But the same process is true. We want to charge them with each of the acts that have violated each of the statutes that we're concerned about.
Okay, at some point, either at advisement, which it usually is, there has to be a finding of probable cause, sometimes at arraignment, but at advisement as well. Just explain what probable cause is.
So
Briefly.
probable cause is different than proof beyond a reasonable doubt, which is what we need to show at the end of the process.
Right.
Probable cause means that it is very likely that a specific person has violated a specific statute. So the officer in that probable cause fact sheet has to set out what we call the elements of the crime. So they have to show each action that was taken in order to prove that the person violated the statute.
Okay. So once probable cause then is found, that's the one way it can be found, but isn't there another way with respect to a warrant before getting to advisement, before making an arrest? What is it that a prosecutor or police officer or an agent, a law enforcement officer can do with respect to getting probable cause determined and obtaining a warrant before they actually make an arrest? Describe that process.
So this would be an instance in which a crime was committed and an arrest was not made at the scene. Either they didn't know who the perpetrator was, or they suspected, but they didn't have evidence. So then the police organization will begin to investigate, and they will work with the prosecutor who gives them the legal advice on what elements need to be found. They will complete their investigation, and if they determine who the suspect is, then they will write an affidavit saying, just like the probable cause fact sheet, all of the elements of the crime that have happened.
Or the facts of the crime.
The facts
right?
of the crime,
that
correct. And then at that point, if the prosecutor feels that there is enough there to show probable cause, then the prosecutor would assist them in drafting an arrest warrant. That arrest warrant would then go to a magistrate judge, and that magistrate judge would determine whether or not probable cause exists to make that arrest.
And once that is determined, then there's a warrant for the arrest, right? And when a person is arrested on the warrant, and the agent or the police officer or the peace officer takes the warrant and serves it on the person and makes the arrest with that warrant, is there a difference between what happens the following day or the following 72 hours at their advisement?
Well, obviously, we have to make sure that the 72-hour requirement is complied with, but then those people can actually also be arraigned at that initial encounter with the court, because we've already drafted, in that case, the charging document.
So in essence, when a judge signs off on a warrant and issues a warrant, that judge already finds probable cause. Is that
correct?
And that's what happens. So probable cause is already found before then. Okay.
Yes.
So then we go to arraignment, as we said. Let's get back to then you're going to arraignment, and at arraignment, after the formal charges are drawn up on the information or on the complaint in the case of misdemeanors, then what happens?
Then the defendant has an opportunity to plead guilty or not guilty. Generally speaking, everyone always pleads not guilty at the initial arraignment, which is the wise thing to do. And then at that point, the case is assigned to a specific judge. And each judge here has different scheduling requirements. So if it's a misdemeanor, it may be set for bench trial right away at arraignment. And that may only be 30 to 60 days in the future. Whereas if it's a more complicated crime, it will be set for pretrial conferences and other things, and a trial date probably will not be set at that initial arraignment.
In the case of a felony or a misdemeanor, under what circumstances is it that a jury trial is required, or the bench trial?
Well, people have a constitutional right to a trial, but they only have a right to a jury trial if the punishment is more than 6 months. So for punishments where it's less than 6 months, they would get a bench trial by a magistrate judge. And in that case, they would not be sitting in front of a jury of their peers. In any other cases, they have the right to a jury trial, but they may choose to have the judge decide anyway. And that's something that they have the right to choose.
Okay. And that is something that happens at what point at arraignment?
No, that can happen really anywhere along the way. As a matter of fact, people can and have started a jury trial and decided in the middle of a jury trial that they want a bench trial, and they have that right.
Oh, so the defendant is for the defendant to determine at that point in time.
Correct.
So we are at arraignment, we plead not guilty. What happens next from the prosecutor's standpoint?
From the prosecutor's standpoint, the case is assigned to a particular prosecutor, and it is then our job to make sure that the defense has all of the information we have. And I think that's really important that people understand that. We're not hiding any balls. The information that we have must be turned over to the defense in a process called discovery. So we do that first.
And that's all information, or all information that's required under the statute. It's not every piece of information, but what about even what we call exculpatory information?
Exculpatory information must be turned over as long as it's in our possession. If it's something that exists in the universe that we don't have, we're not required to go out and find it. But if it's something that's in our possession, we have to turn it over. And the problem with exculpatory evidence is you don't know what might be exculpatory to a defendant. So we might have surveillance videos that they see something in that we don't know about. So we try and turn over as much as we can so that the defendant gets that constitutional discovery. There are periodic trial dates at which the judge is trying to make sure that the case is proceeding in an organized fashion. And it's much slower than I think anybody anticipates. People see things on Law and Order or whatever, and they see that somebody has been arrested on a Tuesday and goes to jury trial the next week, and that's not how any of that works.
Essentially, everything is resolved within an hour.
Correct.
You know, arrest to prosecution to conviction, but it's not as realistic as what we deal with.
So instead, what happens is that the defense attorney needs time to go over all the evidence with their client, and then we start the process of plea negotiations.
Right.
The prosecutor would then make an offer on the case. And the reason that people will choose to plead guilty, the reason that prosecutors will offer that plea, is that it's best for this case to get resolved short of trial for a variety of reasons. Better for the defendant, perhaps, better for the people of the Virgin Islands. So if we can get the resolution that we need through a plea offer, that's very likely to help our caseload and promote justice.
Now, when there is a plea bargain, and then there's a plea of guilty to some of the offenses, is that is what is oftentimes, and some of the offenses are agreed to be dismissed. That guilty plea, is that or is that not a conviction?
That is a conviction, absolutely. Once somebody is convicted, then the parties can agree to a sentencing right away, but it's more likely that the person is going to go over to probation and have a pre-sentence report done. And probation will examine all aspects of that person's life. They will interview the victim. They will look at the nature of the crime. They will look at problems in the person's upbringing or education or anything that a judge might need to know in imposing a fair sentence. And then we would come to the sentencing portion.
And at sentencing, what happens?
At sentencing, the judge tells the defendant what punishment he or she must serve for the crime that they admit to having committed. And that can be anything from probation all the way up to many years in prison.
And it depends on the offense and statutorily what that offense requires. Right?
Correct. And the code does tell us for each offense what the ranges are.
So at that point in time, then there's a sentencing and the judge renders sentence, correct? What happens after that?
At that point in time, the defendant must serve their sentence. And for example, if a defendant is granted probation, especially with a felony conviction, I know that oftentimes members of the public think, oh, well, he just got away with a slap on the wrist. What they don't understand is that if you have a felony conviction on your record, there are very serious consequences. And if, in fact, you're granted probation and you're given a list of things that you must do during that period, and you fail to do them, then you will go back to prison and serve your time there.
And ultimately, who determines what the sentence is the judge.
Is the judge, correct.
So once the judge makes that decision, it becomes a court order. What about when there may have been an attempt to offer a plea or plea bargain, but that doesn't work out, and we decide we're going to trial? So a trial comes up. Tell us about what it takes to prepare for a jury trial. What is that process for a prosecutor, from the standpoint of the prosecutor?
Well, jury trials, because we have the burden of proving everything beyond a reasonable doubt, are much more, I think, onerous for prosecutors than they are for defense attorneys. We want to make sure that we have all of our witnesses lined up, that we have all of our evidence picked out and know exactly what we can and can't do, that we have put together any motions that are appropriate for trial, and that we've also tried to think about what the defense's strategy is and be prepared to counter all of those things when it comes to trial.
And then what about getting witnesses, the evidence together to be able to present? How does a prosecutor go about doing that and the time it takes to do that?
It
for
takes
each case.
a lot of time. And what we'll start doing is making sure that we've had good contact with the witnesses throughout the process. So we're not surprised that somebody has left the territory or, passed away or whatever that is. So we'll make contact and we'll build those relationships with our witnesses. When it comes time for trial and we know the trial date, then we will issue subpoenas and have those witnesses served with subpoenas. And that's not to put anybody on the spot. In fact, that often, I believe, takes pressure off of our witnesses because it's not like they're coming in voluntarily. We are bringing them in so they can blame us if they would prefer not to testify, and they don't have to take that responsibility of, yes, I came forward.
So also there's other evidence other than the testimonial evidence, which would be the witnesses. And then you have, would you not have the officer, the Virgin Islands Police Department? How do the prosecutors and the VIPD work together through the process? I mean, usually the arrests are with the VIPD, as they're usually the first responders, and then the prosecution then takes over. But can you describe how we work hand in hand together to get through from the arrest all the way throughout the prosecution?
Well, we definitely want to encourage officers to understand that the investigation doesn't stop when the arrest is made. There are always more pieces of evidence that we would like to have and that we would continue to seek out and look for, more witnesses that we need to inquire about. And so the officers can help us do that. We as prosecutors can't collect evidence. So we need the officers to go out and get that for us. And we usually have a case agent who spearheads the prosecution and really works with us hand in hand. But we may have several other officers testify at trial as well.
Sometimes there is scientific evidence, DNA, that sort of thing. To what extent is that used in the trials, and how important is it in getting it, and what's the process with respect to that for prosecutors?
So scientific evidence can be anything from DNA to fingerprints to ballistics analysis, anything of that nature. And it's important because that science is what we can use to prove the elements of our case. But we must make sure that all of that evidence has been sent out to the lab, that it's come back from the lab, that we have the expert, that we've disclosed the expert, that we've worked with the expert prior to testifying so they know what the pitfalls in the case are, things like that. And then that can only be presented with the expert there to testify.
Okay. So normally when we talk about sending it to the lab, we're talking about off-island labs, right? Because we don't have a lab here.
Yes, correct.
So these are off-island labs. Okay. Do we work and collaborate with the, let's say, federal authorities also with respect to these, to getting the evidence, gathering the evidence, and presenting it?
We do, and I think we're very lucky because we have a variety of sources that we can use, anything from a private DNA lab to the FBI labs to the National Guard has been very helpful to us very recently.
Okay, let's talk about the jury trial then. Trial starts. What happens?
So the first thing that we're going to do is pick a jury. And that is a process that usually takes about a day. And, I think folks don't like to serve on juries, but it's actually a very fascinating process, and I would encourage anybody to serve on a jury. Once we've selected the jury is sworn in, and at that point what we call double jeopardy attaches, which means that from here on out, if there is a reason why this person is acquitted, then we cannot ever go back and try that person again. We don't get two bites at that apple. Both sides, both attorneys will make opening arguments, and then the prosecution gets to put on our case. And the reason that we get to do that is because it's our burden. At the end of our case, normally speaking, the defense will make a motion in front of the judge to say that we had not met even the basic elements. That really normally isn't granted, but it can be. And then the trial would be over right there. There would be an acquittal and the defendant is free to go. If that motion is denied, then the defendant has a chance to put on his or her case.
If he wants to, he or she wants to.
He or she wants to.
Right, and he doesn't have to. He or she does not have to.
And if they choose not to, then the jury will be instructed that they can't factor that in. The fact that the defendant does not testify does not mean you can infer guilt from that.
And that goes with the defendant's or any person's right against self-incrimination.
Yes.
Correct?
So then at the end of the trial, the prosecutor will make a closing argument. The defense attorney will make a closing argument. The prosecutor then gets a chance to rebut. And then it's sent back to the jury with instructions on how the jury is supposed to process the information. And then it's in the jury's hands.
And then the jury deliberates.
Yes.
And then what happens?
If they are able to come to a unanimous verdict, then they will let the judge know. They will come back in and say what verdict they have come to. At that point, then the defendant will be bound over for sentencing.
So they can be either convicted or acquitted.
Or the jury can decide not to make a decision. Either they can't get all of the people to agree, or they have other issues.
So in this jurisdiction, it's a unanimous verdict of all 12 members of the jury.
Yes.
Right? As in some jurisdictions, there is not. There's a majority. So unless if they don't get that unanimous verdict, as in everyone agrees to either guilt or innocence or guilty or not guilty, then what do we have? What do we call it?
We have a hung jury, and there may be other reasons that we would have a mistrial. And if those things happen, then we have to go back and do it over again.
So the opportunity then, if there is a mistrial or hung jury, then the prosecutors are able to make a decision, right, whether to try the case again.
Yes.
However, for an acquittal,
we're done. That's the end of the day. And of course, if there is a verdict of guilty, the defendant can and will appeal it. And that process may take years, which is another reason that we like plea deals, because those are much more permanent.
Right. And it cannot be appealed. And incidentally, just going for the next step is that once a case is appealed by the defendant, then it's handled also by the Attorney General's office to represent for, but that's a different division. The Solicitor General division handles all of the criminal appeals.
Yes.
With respect to that. What are the kinds of things that happen in between that whole process that sometimes takes a lot of time?
Well, it can be almost anything. And a person does have a right to a speedy trial, but the defense may decide they're not ready to go to trial at a particular point. And the defense may try and continue the process for a longer period of time for whatever reason, strategically. In addition to that, of course, we had COVID. And people couldn't have juries during COVID. So things just sat.
I always say that, a criminal case does not end at an arrest. And it always ends at either a conviction or an acquittal. So you have the crime, there's the arrest, and then you have to go further. Oh, thank you so much for joining us.
Thank you, AG.
So now you know the anatomy of a criminal case. Thank you so much for joining us on Justice Matters.